Why President Biden did not release the Epstein files. What federal investigative records can and can't be released. The main reason the Jeffrey Epstein files are not being released in full is the complicated overlap of ongoing lawsuits, legal procedures, and the need to maintain the autonomy of institutions. Unfortunately, the American judicial system is based on the integrity of ongoing investigations rather than the need for the public to be immediately informed of high-profile cases. Keeping these records under seal follows strict legal protocols so that the government can pursue justice without outside interference or prejudice. The effects of active litigation and judicial integrity. The key elements in the administration's refusal to release these documents during the current tenure are the imperatives of an active grand jury and the appeals process involving key figures such as Ghislaine Maxwell. According to the law, investigative files are kept confidential until a case is completely resolved to protect the rights of the accused and the effectiveness of the prosecution. Where a case is still in litigation, early disclosure of evidence, sometimes called leaking or extrajudicial disclosure, can pose serious difficulties. Maintaining procedural fairness. The judicial system is built on the premise that the courtroom is the right place to weigh evidence. The premature release of sensitive documents influences potential jurors, public perception, and may result in mistrials and successful appeals on the basis that the legal atmosphere was biased. Protection of ongoing prosecution. As of May 2026, the investigation into Epstein's broader network remained active, and the Department of Justice acted to prevent any disclosure that might inadvertently tip off subjects, reveal witness identities, or compromise the collection of evidence essential to future convictions. Follow the law. Federal agencies have not in the past declassified investigative records that are part of an active case. This is not only a policy issue, but a necessity not to interfere with prosecutors' work when they are building a case against accomplices or related persons in the criminal network. Maintaining separation of powers. The second pillar of this decision is the critical institutional boundary between the executive branch and the Department of Justice. The DOJ in the U.S. is supposed to be independent of the political side of things to keep the politics out of the law. The Biden administration, including officials such as former Vice President Kamala Harris, insisted the White House should not and did not have any role in how the sealed documents were handled. Institutional independence. By allowing the Department of Justice to handle its own case files, the executive branch avoids the appearance or the reality of using federal law enforcement to serve political interests. Direct intervention to unseal evidence would probably be viewed as an overreach, damaging public confidence in the neutrality of the federal justice system. Political neutrality is a defensive stance because the Epstein case is high profile and controversial. Any decision to release or withhold information is, naturally, subject to intense political scrutiny. In deferring to the DOJ's professional legal judgment, the administration honored the constitutional norm that criminal investigations are to be insulated from political pressure and partisan agendas. Internal policy consistency. The Department of Justice has been reminded in internal administration guidelines that it is to interpret and apply legal statutes without executive guidance. This means that all investigations are subject to the same uniform rules of procedure and ethical conduct, regardless of the fame or notoriety of the persons involved. Secrecy, privacy, and the grand jury system. In addition to the particular timeline of the Epstein investigation, federal laws on grand jury secrecy serve to offer a robust shield for victims and innocent parties. These laws are not to protect the guilty, but to allow the justice system to work smoothly so that witnesses can testify without fear of immediate retaliation or harassment before a trial is officially started. Grand jury secrecy obligations. Under federal law, information presented to a grand jury, including testimony and digital evidence, must not be disclosed to the public. The secrecy allows for frank cooperation from witnesses who may be deterred from appearing if they know their stories will be immediately under public microscope. Privacy rights of non-charged individuals. The justice system has a duty to balance the public's right to know with the privacy rights of individuals mentioned in files who have not been formally charged with a crime. Publishing these names and information in a broad, unredacted format could inflict permanent damage to the reputations of individuals who may have no direct connection to criminal activity but happen to be included in the investigative record. Judicial review of disclosure. In the end, the court can decide whether the evidence should be unsealed. It is the job of judges to balance the public interest against the rights of the individual. Until a judge determines that the public's need for specific information outweighs the normal protections of grand jury secrecy, the Department of Justice has a legal obligation to continue to seal these materials to ensure that no one's rights are prematurely sacrificed on the altar of public curiosity. Conclusion. In sum, the decision to keep the Epstein files sealed reflects a respect for the underlying principles of American law. The administration has sought to ensure the consistent and fair administration of justice by emphasizing the integrity of ongoing investigations, the separation of executive and judicial functions, and the legal sanctity of grand jury proceedings. This approach may be frustrating to the public desire for immediate information, but it protects the constitutional requirements that are necessary for the long-term effectiveness of the federal justice system.